Good morning, everyone. My name's Russell Rucker. I'm here for another constitutional talk. I'll tell you what I wanted to get to today was our Sixth Amendment, but first we have to review a little bit in the Fourth and Fifth as we work through the rights of the accused. And the Fourth Amendment is kind of an amendment that has to deal with gathering um, information that can be used against you. And so it allows you to be secure in your person, papers, houses, and things of that nature. Facts, it says. And it goes on that on how to swear out a warrant, that somebody has to give an oath or affirmation in order to have a warrant. And it has to go to before a judge, and it has to be sworn. And it has to tell you, as they hand you the warrant, what is to be searched and what or whom is to be seized. But when we get into the Fifth Amendment, it goes on that no person shall be held to answer for a capital or otherwise infamous crime unless a panel of grand jury panel is preceded, and they have to look over evidence to decide if there's enough there to even try you. And then the district attorney would have to go ahead and begin a procedure to try the case. The only exception for not having a grand jury would be if you were in a state of war in which they had to try you on a battlefield. And in that case, you'd have a military tribunal. Okay, but the Fifth also gives you other rights: the rights not to be tried twice, not to have double jeopardy, the right to be quiet, not to be a witness against yourself. They cannot force you to testify against yourself. But if you choose to do so, you can't stop in the middle and refuse to answer cross-examination, for instance. It also gives you a right to, in case your property is seized, they have to give you fair value for your property if it's taken for public good, not if it's taken for a crime of some sort. But then we get up to the Sixth Amendment, and that's really where I want to talk today. Because the Fourth, Fifth, Sixth, Seventh, and Eighth all could be taken together as the rights of the accused. It has to do with criminal prosecutions. It gets into, why we even have an independent judiciary. So in all criminal prosecutions, the accused shall enjoy the right to a speedy trial. What does that mean? Well, it means that within the confines of what is possible, you have to have a fairly speedy trial. I've always thought within a few months, you need to be going to trial. One of the reasons is your witnesses start to embellish things. They start to overthink what they actually saw. It's not that they want to lie before the court. It's just memories have kind of a funny way of doing things. And that's the same way with your police or otherwise law enforcement. Because they have a lot of interactions with an awful lot of people. Virtually every day they're seeing somebody else, and to be actually able to recall all this, it becomes harder the more like the time it goes. So you need a right to a speedy trial so you can get to the crux of whatever it is we're talking about. Okay, and you have that right to that speedy trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall be previously ascertained by law. Okay, so the whole thing here is you can't have the trial moved 1,000 miles away. When we were in the middle of our trouble with England, they would order trials in England. So you would have to travel to England in order to deal with the charges against you, away from places of records where you could prove anything. And this is one of the reasons why you have a right to have that trial take place in the jurisdiction of the crime. Now there are cases in which that couldn't have happened. For instance, during the Boston Massacre, when they tried the soldiers up there, the trial held place in Boston where it occurred, but all the jury members were from outside of Boston. There was a way of making it a fair and legal proceedings. And if you don't know, in that case, the British officers were exonerated, claiming that John Adams, in fact, was their attorney, and he claimed that they had fired in self-defense because they were just in fear of what was being thrown at them. Now, so it was still in the area of the trial, but it can be moved. So it can be moved out of the jurisdiction, it can be moved out of the state if you think, if the jury pool has been contaminated somehow to the point where you wouldn't get a fair trial. And that's the whole objective here, is to have a fair trial. So you be informed of the nature and cause of the accusations to be confronted with, the witnesses against him. So you have a right to face your accuser. So your accuser would have to come in and testify against you, and you have the right to cross-examine him, or your attorneys have that right. To be informed of the nature and cause of the accusation to be confronted with the witnesses against him, to compulsory process for obtaining witnesses. So you have the right to face your accusers, have them come before court, take a stand. You have a right, or your attorney has a right, to cross-examine in order to have a fair process, to actually confront whoever is testifying against you, and to have assistance of counsel for his defense. So you have the right to counsel. And in today's system, generally, if you can't afford a proper counsel, you have a right to have that counsel provided for you. Much the same way as what I was mentioning in the trial of the Boston Massacre, where John Adams was appointed to act as a defense attorney for the British. Something that is just mind-boggling to me, knowing that he would have been opposed to the British in the first place. But it's important to have a fair and equal trial. And just because you have an attorney that acts as a defense of something that you think is just totally horrible, it still is a right of the accused, and it's important to provide the accused, no matter how egregious the crime, so that you can have a fair trial. These are all very important things. Now, I hope you really get the idea of our rights of our accused here as we move on next month, and we'll get into the 7th. I hope you understand what I'm trying to say here and how our system is really supposed to work. Now, that's one of the reasons we have an independent judiciary, is so that the cops and the municipality, wherever it is, or state or whatever, is separate from the judges and the juries. So you have an independent judiciary. So the ones that are bringing the case aren't the ones that are judging you. And with that, I hope you have a good day. I'll see you next time on the next Constitutional Talk. Oh, by the way, please subscribe and hit that bell for me so they know you like us. I really appreciate it. Thank you, and have a good day.